Think you're too young to plan your estate, or that your spouse automatically gets everything when you die? Hi, I'm James Jones, a Washington State estate planning attorney, and I'm here to tell you life doesn't care about your excuses, and neither does probate court. I've watched families unravel over myths and fumbles that a quick fix could have stopped. In this episode, we're tearing down the nonsense like it's only for the rich, and busting myths, correcting mistakes, and handing you the tools to save your loved ones a fortune in fights and hassle. 1 hour now, 0 regrets later. Let's make it happen.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I am your host, James Jones. On today's show, we're talking about myths and mistakes in estate planning. And we're starting with a story, as always. And the story this week is about Johnny. Johnny is in his early 30s, making his way in the world. He had a good tech job here in Seattle, and he was here on his own. He didn't have any family in the area. He wasn't married. I never met Johnny, but I did meet his father, who was forced to come to Washington to deal with Johnny's estate after Johnny died mysteriously while hiking in Snoqualmie Pass. My conjecture leads me to believe that Johnny thought he was too young to worry about estate planning. He wasn't dying anytime soon. He didn't have a family of his own, but he did have a father in Chicago, and he did have assets. He had a 401k, he had some stock holdings through his company, a car, personal property, something substantial. Johnny's estate had to go through the court process of probate, and because he didn't have a will, the state determined where everything went. Half of his assets even went to his estranged mother, who he hadn't had a relationship with in years, and his dad was forced to deal with it by himself from Chicago. Johnny's story illustrates a couple of the myths that we're going to talk about today. Turns out Johnny wasn't too young to have a will, and that it does matter if he did have one. So today we're busting these myths. We're going through about 10 or so myths and truths that you should know that will help you plan your estate, or know, are the things that our friends are telling us right, and should I listen to them at all on this topic, which is usually no, unless they've done it themselves. So let's get into it. Myth number 1, and this started with Johnny: I'm too young to do my estate plan. Like we learned with Johnny's story, accidents don't care about your age. People can die in hiking accidents, car accidents at 25 just as much as they could at 85. And young parents might think, well, I don't have any assets yet. All I've got are these kids. And so they don't think about their estate plan. They don't think that they need a will because they're not going anywhere anytime soon. As long as nature takes its course normally, they're probably here for a while, right? But if they're not, then it's a problem, right? So young parents need to do estate planning because they've got minor kids that need someone to take care of them, a guardian, and they need someone to deal with their money, which would be a trustee, someone to manage money for them because they're too young to have money in their own name. Basic wills, which would be something that a young couple might want or a young person might want, single person, don't take any time at all. Like it might take 2 hours of your time, 1 hour to talk about it, 1 hour to sign it. These are just meeting hours. Okay. They might be much less than that. And age really is no excuse. Johnny's dad would have preferred that he had a will. It would have been much easier for him to deal with his estate. And don't forget 18-year-olds. What if your 18-year-old kid is in high school or turns 18 in high school? What happens then? Well, when they're 18, their moms and dads can't make decisions for them anymore. And they can't talk on their behalf, and they can't talk to doctors for them, and they can't talk to banks for them. And so don't forget 18-year-olds. They should have at least a durable power of attorney. They probably don't have many assets at 18. But one of the things I do is when kids turn 18, we tell parents, hey, let's at least do power of attorney. Let's at least do healthcare directive. So if something happens when they are 18 or when they go to college, you've got the ability to help make decisions. Myth number 2, My spouse gets everything automatically when I die, right? That's not always true. If you don't have a will, state law determines what happens with your estate. And if you're not in a first marriage, like if you have a second marriage where you had kids in another marriage, your spouse will not get all of your stuff automatically. And so you want to make sure that there's a will so that things are straight and the things that you want to have happen do happen. Stepkids or exes can complicate the automatic part. So like I said, if you have separate property or property that you had before you got married to your new wife or husband that you had when you weren't married to them, which is separate property, those assets don't always go to this new spouse, right? Those assets often get shared with stepkids. And make sure you write this stuff down, right? Having things on paper, legally binding agreements, is much better than relying on, well, what the state will say, okay? So myth number 2, my spouse gets everything automatically, is not always true. Do not plan for that. Myth number 3, estate planning is only for millionaires. Okay, so that's not true, right? Like Johnny was not a millionaire. Young couples typically with kids are not millionaires yet. Money in the bank still needs some kind of direction, right? Heirlooms, photos, personal property, that stuff matters too, right? Estate planning is about controlling what happens with your stuff. You know, who gets what, who's in charge. It's not necessarily about the amount of money you have. It can be. And a big part of estate planning is making sure that we're reducing taxes and stuff like that. But the vast majority of people worry more about who gets what and what kind of process it takes for this to happen, okay? Not how much it's worth. So it's not just for millionaires, it's for everybody. Everybody should have an estate plan. Now here's a mistake. You could do the best will or trust of all time, right? You could make a great will with a lawyer or by yourself, whatever, right? But a huge mistake is some people, well, I've drafted my will, but they forget to sign it or they sign it incorrectly, right? They don't execute it properly and that makes it invalid, okay? In Washington, for a will to be valid, it has to have 2 witnesses, disinterested witnesses. These can't be your kids. These can't be, your brother and sister necessarily. If it's unsigned, it's like it never existed. It's worthless. If it's not witnessed, it's not valid. It's worthless. Okay. And most of these wills get notarized. The witnesses' signatures get notarized so that they don't have to testify later. Make sure it's validly executed. Don't just do something online and say, well, I've done my will. They can't be e-signed either, by the way, at least not in Washington. So if you've done a will online or if you've done it by yourself, make sure it is executed properly or it's worthless. It makes no impact on your estate. Okay. Another mistake people make with regard to their estate planning is to not regularly update the thing, right? You've got to update your estate planning for major life events like divorce or new kids or grandkids or whatever, right? If there's a new baby in the house, you need to add them. If you get divorced, you need to remove your ex, right? Well, in a divorce proceeding, usually an ex-spouse is disinherited from a will, but from beneficiary designations, other things like that, that doesn't always hold weight. And it just makes it much easier to clear that up. And old plans or unrevised plans often send money to people or entities or charities that you don't want to benefit anymore, right? And they often have people in charge that you don't want to have in charge anymore. I meet with people all the time that have 30-year-old wills and there might be a kid that's missing. They've got their brother who's 90 as the executor. It just makes no sense to not look at this. I recommend looking at your will or estate plan every 2 to 3 years or at major life events, okay? Just to make sure that you have the provisions in there and the people in there that you want to have in there, right? That it's distributed the way you want it to be distributed. So that's a huge mistake by not doing that. Another myth, I don't need a lawyer. DIY estate planning can work. I can do it by myself, right? So there's lots of will templates online. Simple ones online are probably okay. I meet with people from time to time where they say, well, I did my will online. I want you to review it, James. And in most cases, if it's a simple will and they've got a simple estate, it's probably fine. It's most cases they're fine, right? But if you have a complex estate or if you have a taxable estate or if you've got a complex family, online's not the way to go. The errors that can be caused because the online will sort of runs you through a questioning process that are sort of cookie cutter questions that they don't really know your full situation unless you tell them, don't always work. Right. And paying a lawyer like me to help you make a proper estate plan or proper will or proper trust that's valid and meets your needs and doesn't have a bunch of mistakes in it is a lot cheaper than having to fight about one that doesn't work, right? If you have a blended family, online wills aren't for you, okay? Another mistake that people make with regard to their estate plan or assumption, okay? Assuming that verbal promises hold up. They don't, especially with regard to estates, okay? There's certain things that can be verbal contract or oral contracts. Wills and estate plans are not one of them, okay? I told my son he'd get the house. That means nothing, right? That means nothing carries no weight. The courts need validly executed documents. They don't need talk. They don't need oral agreements with regard to estate planning, okay? Write it down, execute it properly, store it in a safe place, typically. Another myth for you. Probate's no big deal. That can possibly be true, right? Depending on where you live. Washington State is a pretty easy state to deal with probate, but do you want to deal with it, right? Why would you deal with it? Probate is slow and it still costs money, a lot more money than having a good estate plan that avoids probate. It takes months of waiting, thousands of dollars of fees. My probates now are charging in the $8,000 range for a typical probate. They take 6 to 12 months to deal with. It's a big chunk of your life. Avoiding probate makes that time a lot shorter and a lot cheaper. Also, like we've talked about before in this podcast, probates are public record. So your neighbors or friends or enemies, most likely, can look at your estate. They can see what you have, who gets what. It causes problems. And there's even simple things you can do if you have a very simple estate to avoid probate, like joint ownership on bank accounts or even a joint tenant on property or a transfer on death deed. Those things can avoid probate. They're not fail-safes, and I don't always recommend them, but if you're having a simple estate, they can work, okay? Another mistake people make with regard to their estate plan or their wills, they've done it, right? They've done it, but then they hide it, or they put it somewhere where their executor doesn't know where it is. Oftentimes, they put it in a safe deposit box, and those are kind of going the way of the dinosaur now. Their banks are no longer as prevalent. There's not as many branches as there used to be, so there's not as many safe deposit boxes. Problem with safe deposit boxes, if there's not someone on the box with you as an authorized person that has access to the box, they're not getting into that box without opening probate. So if you do put your estate plan in a safe deposit box, make sure that your executor is, or somebody that you trust, is on the box with you and has access rights, okay? If you lose a will, it means it doesn't exist, right? If you don't have a will and you've done a will, but you've lost it or your executor can't find it, you might as well have not done it at all, okay? Share the location or even a copy potentially of your will or trust with your executor, the person in charge, right? So they know where to go. And if you don't want to give them a copy, make sure that the attorney that you did it with, assuming you did it with an attorney, is disclosed to the executor and says, hey, my attorney is James Jones. He's got a copy of the will, okay? And so even if you have a real copy of the will, it's better than having no will, right? You can use a valid copy as long as it's a signed copy. But if there's no will, if it's lost or they can't find it, or if it gets into somebody's hands and they rip it up or they burn it, which happens more often than you would imagine. That's happened to me on a few estates where someone's burned the will or they've disposed of it because they didn't like it, and then the estate becomes intestate and it's a mess. Share the basics with your family. Don't bury the map, as they say, right? Finally, a truth, okay? Small fixes now prevent big messes later. So start today, okay? Doing an estate plan is not too difficult, okay? As far as like meeting time, if you use an attorney, if you use me, we're going to meet for maybe an hour or so to talk about your plan, figure out what you want to do, figure out who gets what, right? What kind of structure makes the most sense. That's going to be about an hour or so. You might have some legwork at home or some things to consider about that too, but that's not going to be a lot of time. And it's not hard work. When everything's drafted, it takes maybe another hour to go through everything, review and sign it. Okay, so that's maybe two or 3 hours of your life to get this done. And it's basically meetings, right? Simple meetings, easy meetings. Even doing a cheap online will beats doing nothing, okay? As long as it's valid and executed properly. Avoiding probate with that kind of a plan is worth not having to hire expensive probate lawyers, right? And so, these small fixes make it much easier for your family to be happy, for them to act on your behalf, and, things will go on, things will go on without you. But don't forget, right? Don't forget. And so making sure that your estate's in place, your plan's in place, can save everybody a lot of hassle, grief, struggle, you name it. Okay. And that's it. That's it for today's episode. Next episode, we're going to be talking about sort of a follow-up to this, how to create a simple and effective estate plan. That's what we're going to talk about. So today we talked about myths, mistakes people make. Next week, follow up with us, how to create a simple and effective estate plan, a step-by-step guide to be exact. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.